versus Tanner Cody Carr, file number 24-7107FH. This time of day is set for Mr. Carr's sentencing. He is present, represented by Attorney Guy Cotter. People are represented by Assistant Prosecuting Attorney Alexander Pahani. On December 4 of last year, a jury of his peers found Mr. Carr guilty of 3 counts of assault with intent to do great bodily harm, less than murder, felonious operation of a vessel, and reckless operation of a vessel. Ms. Karen Eberlin has prepared a pre-sentence report. It's dated January 8th, 2025. There have been sentencing memorandums that have been submitted. The court has reviewed those documents and the documents as well.
An airboat driver from Sebring facing a felony assault charge in a dispute that left an ice fisherman struggling to stay afloat in a Huron County canal. The white bucket in this photo shows where the fisherman was sitting with 2 companions when he ended up in the water in Sebring Township. Investigators say the airboat driver, 38-year-old Tanner Carr, pulled up to the 3 and an argument ensued, likely the result of an old dispute. They say as Carr left, he circled around the 3 fishermen, breaking the ice around them, and took off. 2 avoided going in the water, and in time, they managed to help their struggling companion out.
And Mr. Cotter, have you and your client had the opportunity to review the pre-sentence report?
We have, Your Honor, and we do not have any deletions or corrections at this time.
All right. You agree with that, sir?
Sure.
All right. Mr. Pahani, any objection to the report as well as guidelines?
None from the people, Your Honor.
Thank you. Any objections scoring the guidelines, Mr. Cotter?
Your Honor, I have thoroughly reviewed the scoring of the guidelines, and they are correct. No objection.
Very well. Is there anything you'd like to say on behalf of the defendant or the court imposes sentence?
Yes, Your Honor. Mr. Carr is here, 38 years old, as you can see. Mr. Carr is his family. He has a large family. He has a large group of friends, a lot of community support. In the sentencing memorandum, we provided letters of who Mr. Carr is as an individual. He's a fiance, his father, a son, brother, friend. Court knows in the Compass assessment that in the pre-sentence report, many of the Compass assessment categories show up as unlikely, meaning that Mr. Carr something like this will never happen again. The only thing that was positive was vocational education, which says will be assessed on incarceration. All these are positive behaviors that Mr. Carr currently has. This was an isolated instance, Your Honor. This was not a character of who Mr. Carr is. As I've got to know him over the course of a year since this began, he's become more of a friend even to me. Your Honor, part of the pre-sentence or the sentencing memorandum that the people have provided goes into thorough detail about wanting the guidelines to be between 38 and 120 months for Carr. That is clearly excessive, in my opinion, based off of one event. They mentioned the fact that Mr. Carr has all these misdemeanors. However, in the Slate Act, Mr. Carr has had all of those misdemeanors set aside automatically. So the only convictions that he has on his record are these felonies along with this high court misdemeanors. In addition, Your Honor, they mention the case of People versus Snow. In that case, Your Honor, they rely on the fact that they're trying to send a message to the community stating that certain types of behavior shouldn't be happening because it's repetitive. Well, in People versus Snow, in which the people rely, the reason why there was an extensive sentence for Mr. Snow, the defendant in that case, was because there were 234 convictions for people escaping the Jackson prison. That is nothing like this case. This was an isolated, single event that was before this court. Additionally, Your Honor, that part of the pre-sentence report mentions the special alternative incarceration program. We'd like the court to consider that for Mr. Carr. We think it'd be beneficial to be placed in a program like this. it does state that the court does have a little bit of discretion to state on the record placement if this court permits it. Overall, Your Honor, Mr. Carr is apologetic. The community, victims, his family, many of the letters of support, as I stated, for who he is as a person. That's how they know. They don't see him as someone. They see him as a friend, family member, someone that would take the coat off his back. With everything that is transpired, everything that has been provided to this court, the letters of support, lack of history for Mr. Carr, the fact that we're here today, we're just asking that the recommendation of the pre-sentence report followed today. The rest,
Very well. Does your client wish to address the court?
yes, Your Honor.
I just want to say sorry for the stuff that's happened and heartache that has happened to the families. And thank you for taking the time to do it and allowing me to be out with my family.
On behalf of the people, and this is a victim's rights case.
Yes, Your Honor, and pursuant to the Crime Victims' Rights Act and Amendment, Mr. Kenneth J. Lasesky wishes to address the court. Mr. Kenneth A. Lasesky has drafted a letter which he has asked the people to read, so if the court will hear from Kenneth J. Lasesky.
That's fine. Morning, Mr. Lasesky. What would you like to tell the court?
Morning, Your Honor. I just, in a sense, have dealt with this situation for the past 10 years. As Mr. Carr stated in the trial, that the incident that arose this was because he had an affair with my wife. And I don't think that it's over yet. The way he's been acting, I've still been having his associates flip me off on the side of the road when I see them. And my father hasn't been able to go out in the cold weather because he's got damage to his hands. We tried fishing last week and he had to walk off the ice. He has permanent damage. I've been dealing with this for 10 years and I just want you to consider that in the sentencing. My family's had a lot of damage and I just hope that it's over.
Anything else?
That's it.
Thank you, Mr. Lasesky.
Thank you.
Your Honor, and just for the record, the third victim in this case, Mr. Craig Grimmel, is present. He does not wish to address the court at this time, but I will read into the record a letter drafted by Mr. Kenneth A. Lasesky. And he writes, Your Honor, one thing I love to do is ice fish. I don't do any other fishing. I wait every year for ice. It has been a father and son tradition since Kenny was about 4. We went every chance we could. We went to Canada, up north, didn't matter. We went together every year. But since last February, things have changed for me. I was always one that could come home from work, grab my gear, and go sit on the ice till dark if I wanted. The cold did not bother me. But now it's not the same. I'm lucky now if I can last an hour. My hands start to hurt and get so cold that I can't hold on to nothing. My legs also get cold fast, and I wear the right clothing to keep my body warm. I've gotten so cold now I just shake and have to quit and just go home. Even at my job now, I have to dress differently because now I am cold. This is very disappointing to me because I cannot enjoy what I used to. I want to know if this is my sentence for the rest of my life, while Tanner has been able for the past few months to enjoy himself fishing, hunting, ice fishing. He can enjoy himself because nothing has bothered him. He has no regret that he has injured me in any way. Your Honor, I would like you to take all this into account. I would like to see that Tanner will have to sit and think of what he actually did. He needs to be accountable for his actions. He has lived his life so far getting away with things and has the opinion that he can get out of any trouble. He needs to learn that there's a right and a wrong way to live and that there are consequences for our actions. Your Honor, on behalf of the people, the court has reviewed our sentencing memorandum and the court had the opportunity to hear the testimony and to listen to the facts that were presented to the jury in this case. What should have been an enjoyable morning of ice fishing turned into a day of terror for these three men who were simply out trying to enjoy what Huron County has to offer. They were together, they were enjoying one another's company, and all of that was ruined and destroyed by Mr. Carr's actions on that day. Senselessly and needlessly, Mr. Carr pulled into that cut, destroyed the ice, and only by the grace of God, Your Honor, are we here not for a homicide sentencing as to Mr. Kenneth A. Leseski, who barely escaped the water with his life that day. It was only due to the quick thinking of his son and Mr. Grimmel and a passerby that they were able to get the elder Mr. Leseski out of the ice in time to save his life. Your Honor, if any case comes before this court that deserves top end of the sentencing guidelines, this is it. This may be Mr. Carr's first felony, but what a serious felony it is. Again, it is a miracle that these three men are here in court today before Your Honor, rather than in a cemetery. Mr. Carr must be held accountable for his actions. And Your Honor, despite his words here today, even while he was on bond, he was before this court for a bond violation for thumbing his nose at the court's order to stay off of boats. Couldn't do it, wouldn't do it. There is no reason to believe that Mr. Carr will be successful in any SAI programming because of the fact that he wasn't successful on bond. He doesn't believe that he's done anything wrong, but Your Honor, the jury has spoken. Mr. Carr must be punished for his actions and his future actions must be deterred. And that is why we are asking the court to sentence him to 38 months in the Michigan Department of Corrections to the top end of 10 years.
Any other comment?
Your Honor, I'm sorry to interrupt. I would also add that just as a note, the people did include the notice that of a felony committed with a vessel, and we would ask the court to enter an order that will direct the Secretary of State to prohibit Mr. Carr from operating a vessel on the waters of this state pursuant to statute.
What's the length of that? Do you know?
There is no interim in the manner that that statute was written under the Department of Natural Resources Code.
So it's discretionary with the court.
It is, Your Honor.
Any other comments?
Yes, Your Honor, I'd like to again go back to my sentencing memorandum. Quote to Michigan versus Doolittle case that I quoted in that. The Michigan Court of Appeals in that case found that facts were a man who beat, strangled his girlfriend was probation, because what we were trying to do, or what the Michigan Court of Appeals was trying to accomplish, was to rehabilitate. And had under the belief that people change. We're asking for the special alternative program for Mr. Carr because people can change. They can be rehabilitated. They can be, there can be a prevention of recidivism. We're asking for that today. We're asking for the minimal, or actually the recommendation of the Michigan Department of Corrections of 2 years and 2 months stated in the report. This will never happen again. Mr. Carr has learned through his experience that this is something that affects not only him, but affects his family, his friends, people that surround him. He feels awful about it. We're asking that, again, that the court recommendation of the board.
Thank you. Mr. Carr comes before the court 38 years of age, no prior felonies, 8 prior misdemeanors. Court heard the trial, and I used to ice fish out there when I was a kid too, back in the day, years and years ago. It's been a long time. And as a kid, when your father would take you out there, it was neat just to get out there, number one, but number two, to traverse across the ice, get to your spot, drill the hole, enjoy the day. Hopefully you get something and it makes it a good day. That's what the Leseskis intended to do that day. And it sounds like Mr. Carr did as well at one point, but obviously there's been this, for lack of a better phrase, bad blood. Let's just be honest. There's been an internal feud going on regarding something that happened a number of years ago, which I'm not going to delve into, because we need to move on from that. Everyone needs to move on from that. You hear the victim state as part of victim impact statement that he's still impacted by this. His family's impacted by this, family and friends of the defendant. And, you know, it's real easy for the court to say, hey, come on, let's just stop it and get along. That'd be the easiest thing to say. But I understand. And unfortunately, though, it's one thing to flip someone off. It's another thing to potentially cause them to lose their life, frankly. The elder Liseski doesn't swim. I couldn't imagine being out on an ice floe like that. And really, there was just no justification or excuse for it. Just turn the airboat around, get out of there, stay away. This would have been fine. What I find most troubling, though, about this is beside the fact that the act occurred, testimony was presented during the course of the trial that the defendant had asked, if I recall correctly, girlfriend to monitor scanner traffic. And the testimony from the defendant was, well, I wanted to make sure he was okay. Well, common sense would dictate otherwise. That is, you know, if I created a situation like that, I should go out there. That didn't happen. So that shows me the bad blood, really, to the court. And that's unfortunate because I couldn't imagine being in the situation that these individuals are in. But to make it that much worse, there's no excuse or justification for it. The court has reviewed sentencing memorandums. The court has reviewed the letters that have been submitted. And the court is going to adopt in part the recommendation. I'm going to move backward from it. As to count 6, the marine safety, reckless operation of a vessel, maximum sentence that can be imposed, 90 days in the county jail, credit for 1 day served. Count 4, marine safety, felonious operation of a vessel, will be the sentence of the court. The defendant served 365 days in the Huron County Jail, credit for 1 day served. Relative to both of those counts in the operation of a vessel, the Secretary of State has the authority through the court, because a vessel was used during the course of this felony, the felonies committed by the defendant. The court will order a 10-year prohibition of the defendant operating a motor vessel. And that is going to be actually to count 1, which I'll get to just a bit. As to counts 1, 2, and 3, the court is going to order restitution to Kenneth Allen Liseski in an amount to be determined. We need to have a restitution hearing on that. The court can schedule one. Defendant is to execute a wage assignment to pay the restitution if he's working and misses 2 regularly scheduled payments. Crime victims assessment of $130 will be ordered. DNA testing fee of $60. State cost of $322. As I stated, the commission of a felony with a vessel, advisory, a 10-year prohibition, an operation of a vessel. Finally, it will be the sentence of this court that the defendant be committed to the Michigan Corrections Commission and placed in the commission's custody for a period of not less than 2 years, 5 months to 10 years with credit for 1 day served. That is as to each count. That is the midpoint of the guideline range. It is not the low end. It is not the high end. Defendant has no prior felony record, but let's be honest, he committed a really boneheaded move that day. And I mean no disrespect by that statement, sir, but I couldn't imagine leaving someone out in the water like that. So the sentence will be 2 years, 5 months to 10 years, credit for 1 day served as to all 3 counts, which shall serve concurrently with each other. I hope you learned from this, sir. I hope that when you see these individuals or see any other individual you may have not the best relationship with, is just simply walk away. By doing so, you'll avoid this situation. My duty to inform you of the right to seek leave to appeal. If you're financially unable to provide counsel of your own choice, court will assign counsel for a public expense. Please initial the receipt and questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. Mr. Bahani.
Your Honor, this morning we did receive a receipt for medical expenses from Mr. Liseski. If I may approach the court with that, I've tendered a copy to Mr. Cotter. The amount of out-of-pocket expense is $146.02.
Did you receive, I'm not doubting Mr. Bahani, but for the record, you
Yes, I
received
have
that,
received.
or we'll order that as well. You may present it.
Thank you, Your Honor.
All right, so regarding restitution to be determined, but the court will also order the 146.02. As to the alternative, the program at this point, the court is not ordering. That'll be all. Thank you.